The Supreme Court chamber fell into a hushed silence as Representative Jasmine Crockett approached the podium, her bold red suit standing out against the mahogany interior. Chief Justice John Roberts sat at the center of the bench, his eyes narrowed, fingers drumming on the surface before him. What happened next would stun the nation. Just moments earlier, Roberts had interrupted Crockett 5 consecutive times during her opening statement on voting rights legislation, each time with increasing irritation. The chamber buzzed with tension as some spectators exchanged nervous glances while others leaned forward in anticipation. Roberts, known for his measured demeanor, seemed unusually agitated, his face flushed as he cut her off repeatedly. "Congresswoman, please stick to the legal precedents," he had said for the 5th time, his voice sharp. The room watched as Crockett, a former civil rights attorney, took a deep breath. Her 6th sentence would change everything. As she delivered those words, Roberts' expression transformed from annoyed to stunned. The entire chamber, packed with lawmakers, journalists, and legal experts, fell completely silent. Nobody had ever confronted the Chief Justice like this before, and nobody expected what would happen next. Behind Crockett, her team of legal advisors sat rigid, documents spread before them. They had spent weeks preparing for this moment, analyzing transcripts of past arguments, building a statistical model that would prove irrefutable. The youngest of her team, a recent Harvard Law graduate who had suggested this bold strategy, was now holding her breath, waiting to see if their gamble would pay off. Near the press gallery, veteran court reporters who had covered the Supreme Court for decades exchanged glances, sensing they were witnessing something unprecedented in the court's history. If you're watching this video right now, make sure to hit that subscribe button and turn on notifications so you don't miss our breaking political coverage. Now let's dive deeper into this explosive confrontation that's shaking Washington to its core. The tension between Chief Justice John Roberts and Representative Jasmine Crockett didn't materialize from thin air. It had been brewing for months. John Roberts, 69, had served as Chief Justice for nearly 2 decades. Appointed by President George W. Bush in 2005, he had built a reputation as a cautious institutionalist who occasionally sided with the court's liberal wing on controversial cases. His defenders viewed him as a principled jurist committed to the court's independence. Critics, however, saw him as increasingly protective of conservative interests, particularly on issues of voting rights. After authoring the 5-4 decision in Shelby County v. Holder that struck down key provisions of the Voting Rights Act in 2013, Roberts had faced growing criticism from civil rights advocates. Roberts prided himself on maintaining the Supreme Court's dignity and legitimacy at a time when public trust in institutions was eroding. His clerks described him as meticulous, brilliant, and deeply concerned with how history would judge his court. At conference tables, he was known for his sharp questions and impatience with what he considered poor legal reasoning. Jasmine Crockett, 43, represented a new generation of lawmakers determined to challenge the status quo. Before winning her seat in Congress from Texas's 30th District, she had built a reputation as a formidable civil rights attorney who specialized in voting rights cases. Growing up in St. Louis, Missouri, she had witnessed firsthand how barriers to voting affected communities of color. After graduating from Rhodes College and earning her law degree from the University of Houston Law Center, she had dedicated her career to expanding ballot access. As one of the newest members of the Congressional Black Caucus, Crockett had quickly established herself as outspoken and unwilling to follow traditional protocol when she believed principles were at stake. Her colleagues admired her legal acumen and fearlessness, while her critics dismissed her as inexperienced and disrespectful of institutions. The hearing that brought them face to face focused on the Securing America's Voting Rights Act, a bill that would restore federal oversight of states with histories of voting discrimination. The legislation was designed to address what many considered the damage caused by Roberts' Shelby County decision a decade earlier. Supporters argued it was essential to protect democracy. Opponents called it federal overreach. The stakes couldn't have been higher. With elections approaching and multiple states implementing new voting restrictions, this confrontation would shape the future of American democracy. Roberts believed he was defending the Constitution and state sovereignty. Crockett was fighting for millions of Americans who faced barriers to the ballot box. As Crockett approached the podium that morning, the atmosphere in the chamber was already charged. Several conservative justices had aggressively questioned previous speakers who supported the bill. When Roberts introduced her with a curt, "The court recognizes Representative Crockett," few expected what would follow. "Thank you. Mr. Chief Justice," Crockett began, her voice steady as she adjusted the microphone. "I come before this court not just as a representative, but as someone who has represented voters in courtrooms across America." And then the interruptions began. "Congresswoman," Roberts interjected almost immediately, his voice cutting through her opening statement, "we're here to discuss constitutional principles, not anecdotes from your legal practice." The room tensed. This first interruption came unusually early, even before Crockett could establish her argument. A few gasps emerged from the gallery. CNN's legal analyst Jeffrey Toobin, watching from the press section, raised his eyebrows and scribbled something in his notebook. Representatives from various civil rights organizations exchanged knowing glances. They had predicted Roberts would be hostile, but not this quickly. Crockett nodded slightly, maintaining her composure. "Of course, Mr. Chief Justice. The constitutional principles at stake are precisely why I believe my direct experience with voters is relevant. The 15th Amendment explicitly gives Congress the power to enforce voting rights through appropriate legislation. And Representative Crockett," Roberts interrupted again, his tone sharper, "the court is well aware of the 15th Amendment's text. The question is whether this specific legislation represents a proportional and congruent response to identified constitutional violations, as required by our precedent." The interruption was so abrupt that several veteran court watchers looked up from their notepads in surprise. A law professor from Georgetown, who had brought students to observe what should have been a routine hearing, whispered something to the wide-eyed student beside him. In the front row, Senator Raphael Warnock, himself a vocal voting rights advocate, shook his head slightly. The night before this confrontation, Crockett had rehearsed for hours in her office with her team. They had anticipated Roberts' interruptions, studying his past behavior in voting rights cases. "He'll try to frame this as overreach," her chief legal advisor had warned. "He'll cite Shelby County within the first 3 minutes." The team had prepared a traditional response focused on legal precedent, but at 2 a.m., Crockett had made a pivotal decision. "We need to change the dynamic," she had told her exhausted staff. "If we play by the usual rules, we lose. Let's bring the pattern itself into evidence." Now, standing before the highest court in the land, she could see her young staffers in the gallery, their faces a mixture of anxiety and hope. The youngest, Aisha Johnson, a brilliant researcher who had compiled the interruption statistics, gave an almost imperceptible nod of encouragement. Murmurs rippled through the chamber. Justice Sonia Sotomayor shifted in her seat, exchanging a glance with Justice Elena Kagan. This level of interruption during an opening statement was unusual, even for the sometimes contentious Supreme Court. Crockett took a sip of water, her eyes never leaving Roberts. "If I may continue, Mr. Chief Justice. The record before Congress includes over 4,000 pages documenting modern voting rights violations in the states that would be covered by this legislation. These aren't anecdotes, but systematic evidence of—" "Congresswoman," Roberts cut in for the third time, his voice rising slightly. "The volume of a congressional record isn't dispositive. In Shelby County, we made clear that current burdens must be justified by current needs. And, with all due respect," Crockett pushed back, her voice firm but controlled, "I was about to address precisely how these documented violations demonstrate current needs. The evidence shows that within hours of the Shelby County decision, states began implementing voting restrictions that—" Roberts leaned forward, his face visibly flushed. "Representative," he interrupted for the 4th time, "this court doesn't respond to political talking points. We need legal arguments based on constitutional principles and precedent, not partisan characterizations." The tension in the room escalated dramatically. Justice Ketanji Brown Jackson frowned, writing something on her notepad. Several spectators shifted uncomfortably in their seats. Crockett stood straighter, her hands gripping the podium. "Mr. Chief Justice, there's nothing partisan about presenting evidence gathered by congressional committees. The facts show that following Shelby County, voters in affected communities experienced—" "Congresswoman, please stick to the legal precedents," Roberts said for the 5th time, his voice sharp and dismissive. His interruption was met with audible reactions from the gallery, some supportive murmurs, others disapproving whispers. The pattern was clear to everyone in the chamber. 5 times Crockett had attempted to make her case. 5 times the Chief Justice had cut her off, each interruption more impatient than the last. Reporters in the gallery scribbled furiously in their notebooks. Congressional colleagues watching from the sidelines exchanged concerned glances. In the back of the chamber, Crockett's chief of staff winced. They had anticipated resistance, but not this level of open hostility from the Chief Justice. Among the spectators, Professor Kimberly Crenshaw, whose groundbreaking work on intersectionality had shaped much of the modern understanding of discrimination, watched with particular interest. She had consulted with Crockett's team on the legal strategy, helping them frame the issue not just as a matter of race or gender alone, but as a complex interplay of factors that affected voting access. Now she observed as theory met practice in the most consequential forum in American law. Beside her sat Brian Stevenson, founder of the Equal Justice Initiative, whose decades of work challenging racial discrimination in the criminal justice system had given him a unique perspective on institutional resistance to change. His expression remained carefully neutral, but his eyes never left Crockett's face as she prepared to deliver what they all knew would be the defining moment of her argument. Crockett paused, taking a deep breath. The air in the room felt electric with tension. For a brief moment, it seemed she might back down in the face of the Chief Justice's repeated interruptions. Instead, she adjusted her papers, looked directly at Roberts, and delivered her 6th sentence. The words that would silence the room and change everything. "Mr. Chief Justice," she said, her voice clear and deliberate, "I have here the transcripts from your last 20 oral arguments, showing you've interrupted female advocates at 3 times the rate of male advocates. And I wonder if you're aware that this pattern of selectively silencing certain voices mirrors exactly the voting suppression tactics this law aims to address." The chamber fell completely silent. Roberts froze, his hand suspended mid-air where he had been about to interrupt her again. Justice Kagan's eyebrows shot up. Justice Samuel Alito leaned over to whisper something to Justice Neil Gorsuch. Not a single cough, rustle of papers, or whisper broke the silence. Even the court sketch artist's pencil paused mid-stroke, as if time itself had stopped within the chamber walls. A veteran court reporter would later describe it as the loudest silence I've ever heard in that room. For the first time that morning, Crockett had the floor without interruption, and she was just getting started. "I've brought copies for each justice," she continued, nodding to her aide who began distributing folders to the clerk for distribution. The analysis was conducted by 3 independent academic institutions, and it demonstrates a pattern that I believe is unintentional, but nonetheless revealing about how authority can be wielded to silence certain perspectives. Roberts, recovering from his initial shock, cleared his throat. "Representative Crockett," but Crockett pressed on. "Additionally, Mr. Chief Justice, I've analyzed how your interruptions today align with this documented pattern. Each time you've stopped me, I was attempting to present factual evidence rather than abstract legal theory. Specifically, evidence of how real Americans have been harmed by voting restrictions." The room remained unnaturally quiet. Journalists had stopped writing, their eyes darting between Crockett and Roberts. "This isn't about me," Crockett continued, her voice gaining strength. "It's about a pattern that affects whose stories are heard in this court and whose experiences shape our understanding of the Constitution. And that pattern directly relates to why we need this voting rights legislation." Justice Ketanji Brown Jackson leaned forward, studying the documents that had been passed to the bench. Justice Clarence Thomas, who rarely spoke during oral arguments, appeared to be reading the transcripts with unusual interest. "Mr. Chief Justice," Crockett said, "I'm not asking for special treatment. I'm asking for the same opportunity afforded to others who have addressed this court, to present my full argument without interruption, particularly when those arguments include the lived experiences of voters who have been silenced in a different but equally consequential way." Roberts's face had transformed, from flushed with irritation to a carefully controlled neutral expression. He glanced briefly at the transcript in front of him, then back at Crockett. The confrontation had reached its turning point. Everyone in the chamber knew they were witnessing a historic moment, one that would be analyzed in law schools and political science classrooms for years to come. The question hanging in the air: how would the Chief Justice respond? The seconds stretched into an uncomfortable silence as Chief Justice Roberts studied the documents before him. His face, normally so controlled, betrayed a flash of genuine surprise as he flipped through the pages. "Representative Crockett," he finally said, his tone markedly different, measured, cautious. "You've made a serious allegation about the conduct of this court. I'd like to address it directly." The gallery tensed, anticipating a harsh rebuke. But what came next stunned everyone present. "While I would disagree with some of your characterizations," Roberts continued, "I appreciate that you've brought data rather than anecdotes to our attention. That's precisely the kind of evidence-based approach this court should value." A collective intake of breath swept through the chamber. Justice Barrett leaned forward with interest. Justice Sotomayor's expression remained carefully neutral, but there was a glimmer in her eye. Roberts wasn't finished. "I would submit, however, that interruptions often occur when the court needs clarification or when an advocate has strayed from the legal questions at issue. But your point about ensuring all voices are heard equally in this chamber is well taken." He set the documents aside deliberately. "Please continue with your argument, Representative. You'll have the same time afforded to other speakers, without further interruption from me." Crockett nodded respectfully, the faintest smile crossing her face. "Thank you, Mr. Chief Justice." What followed was 5 minutes of uninterrupted, powerful testimony. Crockett methodically outlined the evidence of voting restrictions that had proliferated since the Shelby County decision. She cited specific cases where voters had been turned away from polls, where DMV offices in minority neighborhoods had been closed just as voter ID laws were implemented, and where polling places in communities of color had been eliminated, creating hours-long lines. "This isn't abstract theory," she emphasized, her voice resonating through the chamber. "This is the systematic undermining of the most fundamental right in our democracy." She then pivoted to the legal framework, explaining how the proposed legislation was narrowly tailored to address specific violations, how it created a coverage formula based on current evidence rather than historical patterns, and how it included mechanisms for jurisdictions to earn their way out of pre-clearance requirements through clean records. This legislation represents Congress exercising precisely the authority granted by the 15th Amendment to enforce voting rights through appropriate legislation, Crockett argued. It respects this court's concerns in Shelby County while addressing the very real problems that decision unfortunately unleashed. As she spoke, something remarkable happened. The justices began engaging with her arguments rather than dismissing them. Justice Barrett asked about the standards for removing jurisdictions from coverage. Justice Kavanaugh questioned how the law would apply to specific types of voting regulations. Even Justice Alito, often skeptical of voting rights legislation, asked a substantive question about the evidence collection methodology. Court observers in the gallery were visibly stunned. A veteran Supreme Court reporter from the Washington Post nudged her colleague and whispered, "I've never seen Alito engage this constructively on a voting rights case." A constitutional law professor who had written extensively on the Roberts Court was furiously taking notes, already mentally drafting the law review article this unexpected exchange would inspire. Near the back, former Attorney General Eric Holder, who had championed voting rights for decades, sat forward in his seat, his expression a mixture of surprise and cautious hope. For each question, Crockett had a precise, legally sound answer. She cited cases, statistics, and constitutional principles with the ease of someone who had lived and breathed voting rights law for decades. When Justice Thomas, who rarely spoke during arguments, asked about the bill's impact on state sovereignty, a hush fell over the room. It was widely known that Thomas had been a staunch opponent of federal voting rights oversight. "Justice Thomas," Crockett replied, "state sovereignty is certainly a vital constitutional principle. But the Reconstruction Amendments specifically altered our federalist structure to ensure that states could not deny fundamental rights to their citizens. The 15th Amendment explicitly gives Congress the power to limit state sovereignty in this specific area. recognizing that voting rights require federal protection. Thomas nodded slowly, making a note on his pad. What observers in the gallery couldn't see was the detailed preparation behind this exchange. 2 weeks earlier, Crockett had convened a mock Supreme Court in her office, with experienced attorneys playing each justice. The attorney playing Thomas had grilled her for 3 hours straight on federalism principles, forcing her to refine her answers until they acknowledged states' rights concerns while firmly establishing congressional authority. That preparation was now paying dividends, as Thomas, who had written scathing dissents against federal voting oversight, appeared to genuinely consider her response. Professor Melissa Murray from NYU Law School, seated in the second row, nudged her colleague. As one of the nation's foremost scholars on the Reconstruction amendments, she had advised Crockett's team on framing their arguments within the historical context of the post-Civil War constitutional transformation. Hearing her scholarship translated into such precise and powerful advocacy before the highest court brought a rare smile to her usually serious demeanor. But the most remarkable exchange came when Chief Justice Roberts himself asked a question, not as an interruption, but as a genuine inquiry. "Representative Crockett," he said, "you've presented evidence of voting restrictions following Shelby County. How do you respond to the argument that these are merely states implementing legitimate election integrity measures, which they have a sovereign interest in doing?" The room held its breath. This was the central question at the heart of modern voting rights disputes. Crockett nodded, recognizing the gravity of the question. "Mr. Chief Justice, election integrity is indeed a compelling state interest. No one disputes that. The question is whether these specific measures actually serve that interest, or whether they disproportionately burden certain communities with minimal security benefit." She held up a document from her file. "The data is revealing. In states previously covered by pre-clearance, voting restrictions have been implemented that demonstrably reduce turnout among minority voters by 5 to 10%, while addressing forms of fraud that, according to these states' own investigations, occur at rates of less than 0.001%. She passed the document to the clerk, who distributed it to the justices. "This isn't about preventing states from securing their elections. It's about requiring that security measures be designed in ways that don't unnecessarily burden the fundamental right to vote." Roberts studied the new document, his brow furrowed in concentration. "And crucially," Crockett continued, "the legislation before you creates a process where jurisdictions must simply demonstrate that their proposed changes won't have a discriminatory effect. If they can show that, they can implement whatever measures they believe necessary for election integrity." Justice Kagan nodded almost imperceptibly. As Crockett's allotted time neared its end, she delivered her closing statement with quiet intensity. "Members of the court, the right to vote isn't just another legal issue. It's the right upon which all others depend. When we allow it to be compromised, we undermine the very foundation of our constitutional system." She gestured to the packed chamber. "The eyes of the nation are on this court, not just because of the legal principles at stake, but because millions of Americans want to know if their government still believes their voices matter." Crockett paused, meeting the gaze of each justice in turn. "The question before you isn't whether Congress has overstepped its authority, but whether this court will allow Congress to exercise the explicit power granted by the Constitution to protect the most fundamental right in our democracy." The chamber was so quiet that when she turned a page in her notes, the sound seemed to echo. 3 rows back, Sherilyn Ifill, the former president of the NAACP Legal Defense Fund, who had argued landmark voting rights cases before this same court, watched with a mixture of pride and amazement. Beside her sat Stacey Abrams, whose voting rights organization had provided much of the data Crockett was now presenting. Their presence wasn't coincidental. They had spent hours helping Crockett prepare for this moment, wargaming every possible interruption and objection. As she finished, the chamber remained silent for a moment, absorbing the weight of her words. Then something unprecedented happened. Chief Justice Roberts spoke directly to her, outside the usual protocol of oral arguments. "Representative Crockett," he said, his voice carrying clearly through the chamber, "I want to acknowledge something. While the court will of course reserve judgment on the legal questions presented today, Your presentation has been instructive. He glanced briefly at the interruption data still sitting before him, and perhaps a reminder to all of us on the bench about the importance of hearing arguments fully before forming conclusions. A murmur spread through the gallery. Had the Chief Justice just conceded a point to the Congresswoman he had repeatedly interrupted minutes earlier? Roberts continued. This court has always maintained that our constitutional democracy depends on the robust protection of voting rights. The question has always been how to balance that with other constitutional principles. Your arguments today will be given the full consideration they deserve. As Crockett returned to her seat, the atmosphere in the chamber had transformed completely. What had begun as a tense confrontation with repeated interruptions had evolved into one of the most substantive and potentially consequential discussions of voting rights the court had heard in years, and it had all turned on that sixth sentence, the moment when Crockett had refused to be silenced and instead had directly confronted the very pattern her legislation sought to address. Outside the Supreme Court, a crowd had gathered, following the proceedings via updates from reporters inside. As word spread of what had transpired, spontaneous applause broke out. Inside, as the next speaker was called, Justice Sotomayor slipped a note to Justice Jackson. The contents would not become public until years later, when Jackson mentioned it in her memoir. Sometimes the most important legal arguments are the ones that make us confront our own patterns. Today might be historic. Within minutes of Crockett leaving the Supreme Court chamber, her confrontation with Chief Justice Roberts exploded across social media and news outlets. Journalists who had witnessed the exchange rushed to file their stories, their headlines capturing the dramatic moment. Crockett confronts Roberts with his own record. Chief Justice silenced by data on interruptions. Historic showdown at Supreme Court changes voting rights debate. CNN went live with breaking news coverage as legal analysts struggled to contextualize what they had just witnessed. In my 30 years covering the Supreme Court, said veteran court reporter Joan Biskupich, I've never seen anything like this. A member of Congress directly confronting the Chief Justice with data about his own behavior, and him actually acknowledging the point. It's unprecedented. In CNN's Washington studio, a heated panel discussion erupted between legal commentators. What Crockett did was disrespectful to the court's traditions, argued a former clerk to Justice Alito, his voice tight with indignation. There are established protocols for these proceedings. And one of those protocols should be equal treatment of advocates regardless of gender, fired back a constitutional law professor from Columbia, leaning forward in her chair. The data doesn't lie. This wasn't just about Crockett. This was about a pattern affecting countless female advocates who've appeared before the court. The network's chief legal analyst, who had argued before the Supreme Court numerous times, shook his head in amazement. What's truly extraordinary is Roberts' response. Any other Chief Justice in history would have shut this down immediately. The fact that he engaged with the criticism tells you something profound has shifted. On social media, Crockett silences Roberts and the interruption became the top trending hashtags within the hour. A clip of Crockett delivering her sixth sentence, showing Roberts' frozen reaction, had already been viewed over 5 million times across platforms. MSNBC's Lawrence O'Donnell opened his show that evening with, "Today, we witnessed something extraordinary. A power dynamic reversed through nothing more than preparation, courage and cold, hard facts." Meanwhile, Fox News took a different approach, with Laura Ingraham arguing, Representative Crockett showed a fundamental disrespect for the highest court in the land by ambushing the Chief Justice with these statistics. Whatever happened to decorum and proper procedure? Inside the Capitol, as Crockett returned from the Supreme Court, she was met with a hero's welcome from her Democratic colleagues. Speaker Jeffries approached her first, shaking her hand firmly. "You just changed the conversation on voting rights," he told her, loud enough for nearby reporters to hear. "This isn't just a news cycle win. This is a fundamental shift in how we approach this fight." The hallways were lined with staffers and representatives who had watched the proceedings on C-SPAN. Some held up their phones displaying the trending hashtags. Others simply applauded as she walked by. A group of young black congressional staffers had formed an impromptu reception committee, one of them holding a hastily made sign reading, "Crockett called him out." Representative Alexandria Ocasio-Cortez embraced her, whispering, "You did what many of us have wanted to do for years." Even some Republicans privately expressed admiration for her preparation and poise. A senior Republican senator was overheard telling a colleague, "Agree with her or not, she came armed with facts, not just talking points. We could learn something from that." In the White House, the president's advisors were hastily rearranging the schedule. What had been planned as a routine statement on voting rights was now being elevated to a prime-time address from the Oval Office, set to air the following evening. "The landscape has shifted," one senior advisor explained. "The Crockett moment has created an opening to push harder on this legislation." Back in the offices of the Congressional Black Caucus, Crockett met with her team, still processing what had transpired. Her chief of staff couldn't contain his excitement. "The phone is ringing off the hook. Every news outlet wants you. CNN, MSNBC, 60 Minutes The View. Everyone." Crockett raised a hand, calming the room. "This isn't about media hits," she said firmly. "This is about using this moment to push the legislation forward." "What's the reaction from swing votes in the Senate?" Her legislative director flipped through messages on her phone. "3 senators who were on the fence have already called. They want to meet tomorrow to discuss amendments that might address some of their concerns. They're suddenly very interested in being part of this process." Meanwhile, in the Supreme Court's private conference room, the 9 justices had gathered for their scheduled post-argument discussion. What normally would have been a structured deliberation about legal principles had turned into something more reflective, according to accounts that would later emerge from clerks and a justice who spoke anonymously to a biographer. Roberts opened the discussion with unusual candor. "Before we address the merits of today's arguments," he reportedly said, "I think we need to acknowledge what transpired. Representative Crockett presented data suggesting that perhaps all of us, may have patterns of interaction that unwittingly silence certain voices." Justice Alito, a staunch conservative, apparently pushed back. "Chief, you can't seriously be suggesting that this court should change its approach to oral arguments based on what amounts to a political stunt." But Justice Kagan interjected, "Is it a stunt if the data is accurate? I've reviewed these interruption patterns and the numbers are stark. If we're genuinely concerned about hearing all perspectives, which we should be as the highest court, shouldn't we at least consider what this means?" Justice Barrett, often a swing vote in recent cases, added, "The legal profession has been grappling with these issues for years. Studies show similar patterns in lower courts and law firms. Perhaps the court isn't immune to broader societal patterns." No formal decisions were made that day about the court's approach to oral arguments, but seeds had been planted. In the following term, court observers would note a marked decrease in interruptions from the bench, particularly of female advocates. As for the voting rights legislation itself, the confrontation had dramatically altered its prospects. Editorial boards across the country published pieces supporting the bill. Legal scholars who had been skeptical wrote new analyses suggesting the legislation might indeed address the court's concerns from Shelby County. 3 days after the hearing, another remarkable development occurred. Chief Justice Roberts, who rarely gave interviews, agreed to appear on PBS NewsHour with Judy Woodruff. When asked directly about the confrontation with Crockett, he surprised viewers with his response. "The Supreme Court isn't infallible," he said carefully. "We're 9 individuals trying to interpret the Constitution as faithfully as possible." Representative Crockett made a point about ensuring all voices are heard equally in our chamber. "That's a principle I believe in, and if there are patterns that undermine that principle, they deserve examination." When pressed on whether this meant he was reconsidering his position on voting rights legislation, Roberts reverted to his judicial caution. Each case must be judged on its specific merits. "But I will say that the evidence presented this week was substantial and will be given serious consideration." The interview sent shockwaves through the legal community. That evening, a hastily organized panel discussion at Harvard Law School drew standing room only attendance. Distinguished professors debated whether Roberts' comments represented a genuine evolution in his thinking or a strategic move to protect the court's institutional legitimacy. "What we're witnessing is unprecedented," argued Professor Lawrence Tribe, a constitutional scholar who had argued numerous cases before the court. A sitting Chief Justice acknowledging, even indirectly, a pattern of behavior that might affect the fundamental fairness of the court's proceedings. This goes beyond the voting rights case itself. It touches on questions of institutional bias that have been raised by scholars for decades, but rarely addressed directly by the justices themselves. Behind the scenes, sources close to the court revealed that Roberts had convened an unusual private meeting with the other justices the day after the hearing. While the content of their discussion remained confidential, one clerk described the atmosphere afterward as thoughtfully somber. Another reported seeing Roberts carrying a thick binder labeled Questioning Patterns Analysis into his chambers late that evening. For voting rights advocates, this measured statement from the Chief Justice represented a seismic shift. Groups that had been fighting for years to restore the protections of the Voting Rights Act saw a new opening. In the weeks that followed, momentum continued to build. 3 Republican senators announced their support for an amended version of the bill, giving it a filibuster-proof majority in the Senate. State legislators who had championed voting restrictions began facing uncomfortable questions about the data Crockett had presented, with some walking back their most controversial measures. The personal stories began emerging too. In Georgia, a 94-year-old civil rights veteran named Josephine Baker, who had marched with Dr. King in the 1960s, went public with her story of being turned away from the polls in 2022, despite having voted at the same location for over 70 years. Her story, shared in a viral video where she directly thanked Crockett for fighting for her right to vote, put a human face on the statistics. In Arizona, Native American tribal leaders organized a caravan to state capitals, documenting the 3-hour drives many tribal members faced to reach polling places after closures in their communities. In Texas, university students held register-a-thon events where they shared their experiences with new ID requirements that didn't recognize student identification. These stories, which might once have been dismissed as anecdotal, were now being covered by major news outlets as evidence supporting the legislation Crockett had defended. 6 weeks after the confrontation, the Securing America's Voting Rights Act passed the Senate with a surprising 62-38 vote. As the bill headed to the president's desk for signature, political analysts universally traced its success back to that moment in the Supreme Court when Crockett's 6th sentence had changed everything. The law itself represented the most significant expansion of voting rights protection since 1965. It restored federal oversight of states with recent histories of discrimination, created new pathways for voters to challenge restrictions, and established clear standards for measuring the impact of voting changes on minority communities. For Crockett, the personal impact was profound. Once seen as a junior member of Congress still finding her footing, she had become one of the most influential voices on civil rights in a generation. Law schools invited her to give lectures. Civil rights organizations created fellowships in her name. Young lawyers cited her as their inspiration for entering public service. But perhaps the most telling indication of her impact came 8 months later, when the Supreme Court heard its first challenge to a voting restriction under the new law. As oral arguments began, Chief Justice Roberts made an unusual announcement. Before we proceed, I want to note a change in our approach to these proceedings. To ensure we hear arguments fully, the court will be more mindful of allowing advocates to complete their thoughts before questioning. Our goal is to understand all perspectives, not just those that align with our initial impressions. Legal observers immediately recognized the significance. The confrontation hadn't just changed one law. It had begun to transform the institution itself. 3 years later, when the court upheld key provisions of the Voting Rights Act in a landmark 6-3 decision, Justice Roberts wrote in the majority opinion, "The right to vote is preservative of all rights in our constitutional democracy." When Congress acts with clear evidence to protect that right using its 15th Amendment powers, this court should be appropriately deferential. The passage was widely interpreted as a direct reference to the evidence Crockett had presented that day. On the 5th anniversary of the confrontation, now Senator Crockett gave an interview reflecting on its legacy. "That moment wasn't about me challenging the Chief Justice," she said. "It was about data challenging assumptions. It was about evidence confronting pattern. And most importantly, it was about ensuring that in our democracy, no voice, whether in a courtroom or at a polling place, is systematically silenced. Political. Scientists would later identify the Roberts Crockett confrontation as a pivotal moment in 21st century American democracy, the day when a pattern of silencing was itself silenced by the power of evidence and courage. The story ultimately transcended party lines, becoming a case study taught in law schools about effective advocacy, in communication courses about the power of preparation, and in history classes about how individuals can change institutions. Law students at Harvard, Yale, and Howard began annual competitions where they would simulate the Crockett method, preparing not just legal arguments, but also analysis of the patterns of questioning they might face from judges. The Crockett Fellowship for Voting Rights Advocates was established, funding young lawyers dedicated to expanding ballot access. In courtrooms across America, lawyers began citing the sixth sentence rule, the principle that sometimes confronting procedural inequities directly is necessary before substantive arguments can be heard. Perhaps most tellingly, the incident sparked a technological innovation. Several courts began implementing analytics dashboards that tracked judicial questioning patterns in real time, allowing judges to self-monitor their engagement with different advocates. A judge in the Ninth Circuit Court of Appeals called this the Crockett metric, noting that awareness is the first step toward improvement. The societal impact extended well beyond courtrooms. College debate teams restructured their format to ensure equal speaking time regardless of gender. Corporate boardrooms installed similar analytic systems to monitor interruption patterns in meetings. The American Bar Association revised its judicial ethics guidelines to include a section on equitable engagement with advocates, with specific reference to interruption patterns and their potential impact on fair proceedings. Scholarly research exploded in the wake of the confrontation. The Roberts Crockett effect became shorthand in academic circles for how data transparency could transform institutional behavior. The Stanford Journal of Law published a landmark study examining 50 years of Supreme Court oral arguments, confirming and expanding on Crockett's initial findings. This research was cited in judicial training programs worldwide, from the International Court of Justice to local traffic courts. Dr. Rachel Givens, a cognitive psychologist who specialized in communication patterns, conducted groundbreaking research on what she termed authority-mediated silencing, the phenomenon Crockett had exposed. Her findings suggested that awareness alone reduced interruption disparities by 40%, while active monitoring systems achieved up to 70% improvement. The Crockett confrontation, as she called it in her best-selling book, had created a natural experiment that advanced understanding of institutional bias by decades. As one historian would later write, "Some moments in a nation's journey appear small at first, a sentence spoken, an interruption confronted, but they create ripples that eventually reshape the landscape of democracy itself." The day Crockett silenced the room with her sixth sentence was such a moment. Decades later, this confrontation would become required viewing in civics classrooms across America. Teachers would pause the recording right before Crockett's sixth sentence and ask their students, "What would you say in this moment? How would you challenge authority with evidence rather than emotion?" The answers would vary, but the lesson remained consistent. Democracy thrives when patterns of exclusion are named, measured, and confronted. In her final interview before retirement, conducted on the 30th anniversary of the confrontation, Crockett reflected on the broader meaning of that day. "People often ask if I was scared to confront the Chief Justice," she said, her eyes still sharp despite her advanced age. "But what scared me more was the thought of staying silent when I had evidence that might change the conversation. There's a special kind of courage required to speak truth with data rather than just passion. That's the legacy I hope lives on. If you found this story powerful, don't forget to like, share, and subscribe to our channel. Hit that notification bell so you'll never miss our in-depth political coverage and analysis of the moments that are shaping America's future. Leave a comment below telling us what you think about this historic confrontation and its impact on voting rights.